but you can protect in the copyrights. Why I'm saying is, even if you're thinking that it is not protected in one type of IPR, then you can protect using the other IPRs. Okay, so if you, for example, if you're having a drawings, okay, that may be an engineering drawing, right? So engineering drawing, you can protect using a copyright. At the same time, the engineering work or the technical work, what the idea, what you are involving, that can be protected in the patent. Okay, so next will be the trademark. Trademark, it is related to the industry. I think even the colleges have the trademark, right? So logos you have. The logos will be protected using this trademark registration. So you can have an application for that logos and you can apply for that. Not only the logos, they have the sound logo also. Like for sound also, you can protect it. So for example, AVR cinemas, they have a line, barking of a line, right? Like sound of the line, it is protected under this trademark. Okay, and except smell and taste, it is other things are being protected in the trademark. And another one is industrial design. Industrial design, actually, as of like it is different from the copyright, which means that this design we can use it only for the appealing products, appealing appearance of the products. Okay, whereas in case of a copyright, you can get the you can get the copyright for your idea, whereas here you will be getting only for the appearance. Okay, it is only for the designers, or it is only like outside design, you can get the IPR for them. So it is the industrial design, it doesn't involve any patents. Okay, so next will be the geographical indications. I think many of you might have known. And each and every location of India or in the world also, there will be some speciality with, it is associated with your locations, right? For example, in Chennai, we can, Kanchipuram, we can say Kanchipuram silks, right? In Andhra, what we can say, some speciality associated with the dolls with the Kontapalli, right? So that we will that is especially for that particular area. Those who are involving trade in that area, they will be given this rights. Okay, so that is geographical indication. Now this is getting popular, and it is a urgent need for us to identify those IPRs available, and we have to educate them to get these rights. And it is a well-known protecting equipment to protect our geographical indications. And next one will be the semiconductor IC design. It is not familiar in our India, since it is dealing mainly with the VLSI design. VLSI, I think VLSI you might be knowing, right? So in the VLSI design, you will be laying out the transistors and nano levels you will be using. That type of design will be protected in the semiconductor IC design. Till now, only 2 applications has been sanctioned. Only this ISRO as well as the other one, Bell. Only those application has been given, but recently, like they are trying to take the steps to include these also, other applications also. And if you're working in the VLSI, please be aware of these one and try to apply for this. Okay, I think you will be knowing this Gerber file and other things, right? So in the VLSI, you will be, after that, you will be creating some Gerber file, other things, right? So that you will be have to produce in that department, that is office, GI office, then you will be getting the protection for that. So this is not becoming popular, but it is necessary that we have to strengthen this. And last one is the plant varieties and farmers' right. And particularly if you see the farmers, they will be having a knowledge, traditional knowledge, and based on the traditional knowledge, they will be creating some new varieties of seeds, right? So they will be having some new varieties of seeds. So these varieties of seeds, they will be having protected using this farmers' right. So farmers will be getting up exclusive rights for them, for what they have found out. Okay, so they will be finding out some different varieties based on the traditional knowledge. So that will be protected under this plant varieties and farmers' right. So these are the general varieties, central types of IPRs we are provided in the India. Apart from that, in other countries, we have the trade secret. And in this trade secret, in all other except the trade secrets, in all other properties, we have to tell all the details about our ideas as well as the inventions. Okay, in other IPRs, we have to tell about our all ideas and everything, put it in a documents, and then we have to submit it. Whereas in the trade secret, what we will be doing, we will not reveal everything to the IPO office, that is patent office, and we will be trying to conceal something. Okay, so that concealment, it comes under trademark. For example, the Coca-Cola is a trade secret because the formula is not known till now. Okay, so it is not known till now, but it is protected under trade secret. But in India, it is not allowed here. Okay, so trade secret, it is not being done in India. Okay, so only in India, only 7 are being done. Trade secret is not being done. And these are general details about the IPR. I have told you about what is the different IPRs, and these are the protections related to that. For example, the patent, it is for 20 years. So once you got the patent, then you can use your as a monopoly document, like a monopoly as for 20 years. After that, it becomes a public domain. You cannot restrict the others to use your property. So the validity period of the patent is 20 years from the date of filing. All these details are from the date of filing. Okay, so not even from the date of granting. Granting is different, filing is different. Once you have filed it, it may grant or it may not be granted. Once it is granted, then the date will be from the date of filing. Okay, so it is from the 20 years. Grant may be taking after 5 or 6 years, but your validity will be starting from that beginning of your application. Okay, 20 years. And the criteria used there will be novelty, inventive step, and industrial applicability. Novelty means its idea should be new one. Idea should be new one. Okay, and the inventive step means that step, whatever you are having the inventive step, that should not be obvious for an expertise. That should not be obvious for an expertise. And next one will be the industrial applicability. If it is not used in the industry, then it will not be useful. Okay, so actually this was shown earlier by my colleague. So it was presented in other seminar also. So in the same college, so I'm not going much detail into this. Okay. Ma'am, actually patent granted, once it is filed, automatically it gets published. After that, it will be going for an examination. Examination will be done by the patent office or the IPR office. If it is a copyright, then it is an IPR office. Once the office has mentioned that this is a novel or whatever the criteria it is satisfying, then they will grant it. No, publication it takes automatically. Whether it is granted or not granted, it will take automatically. It is like a open. It is like a once you have done it, then it will be open for public. If the public has any objection, then they can file opposition for that. Once you have overcome all the oppositions, then you can get the grant. Yeah. So opposition can be from the common people or from the patent office or the IPR office also. So that examination part you have to go through. Once that examination will be done only by the patent office. But other common people, they can object at any stages. Even after the grant also, they can object it. This is my idea or that is your idea. Like that, they can object it. And even for the patentability also, they can object it and they can withdraw it. But if our points are very strong, then you can certainly protect it. Then you can overrule all these objections. Okay. So the patent, whatever the criteria given for each and every IPR, it is given that. Only for patent, it is a 20 years because it is taking a lot of materials, efforts, and energy. So it is having a 20 years lifetime period. And nowadays, for universities as well as college institute, the fees has been reduced. It is only 1,600 for filing the application. And apart from that, you will be having the examination fees, that is only 4,000. So within 5,000, you can complete everything. Okay, so yeah. And apart from that, we have the copyright. Copyright, it is a lifetime of an author plus 60 years. Okay, so plus 60 years it is being given, but after that it becomes public. Public means you can take it, you can sell it, and you can do it for any purpose. Okay, but before that we can do it. You have to ask permission from the author or the inventor. Then only you can use it or you can sell it. Otherwise, you cannot use it also. And yeah, after that industrial design, it is only for 15 years, 10 plus 5 years only. After that, it becomes invalid, like validity expired, not invalid, it is validity expired. Okay, but after that, you can use it. And what are the other things? Semiconductor layout, it is only for 10 years. Okay, because why it is a lesser period? Because it's the intellectual involved is very less. Okay, so industrial design, it's outer structure only, right? So it is appearance only. We are not going to spend much of your technical intellectuals, right? That's why the year is very less. Okay. And trademark, actually lifelong we can do it. Like 10 years, first 10 years you have to pay. After that, you have to pay for 5 years, and then you have to extend any number of years. Okay, so now you can see that even after 100 years also, you can see that symbol or logo of that company, right? So because the trademark is for throughout the lifetime of the business. Okay, business never ends, right? Business we have to consider as a separate entity which will last longer. Okay, it is considered as a separate entity and it will be which lasts longer. The trademark is one such property which is helping the business. Okay, so it is going on. Okay, and another one is geographical indication. Is this again similar to the trademark, because it is a intellectual property given to the particular area, right? So for that particular area, it is given, and it is also developing a business for them, right? Therefore, it is also like a lifetime. After 10 years, you have to renew for 5 years, 5 years, 5 years, then you can go on. So for example, if you are having that doll, Madanapalli doll, then what you can do is after 10 years, they will be getting, after that 5 years, they have to renew it. And once you are doing, the people only in the Madanapalli, they can be able to do it. Others, they cannot mention that even if they are going out and they are doing, it is not allowed. Okay, once it is produced in the same village, then only it is considered as a geographical indication. They will not be allowed to shift outside. That is the advantage of this geographical indications. And many products are being added into it. And next one is the plant varieties. And plant varieties, if you see, there are different types of plants. And for the trees, it is 18 years because they have to grow up to 18 years. After that, they will be checking. So because they have to have so many, they have so many testers, like a dust test we will be having. Dust test means all the plants, whatever grown through some modification of the seeds, it should be distinct. Distinct means it is different from the regular one. Okay, it is different from the regular one. And it should be a uniform. Uniform means one seed should not produce a longer one and another seed should not produce a shorter one. It should be having a uniform variety of plants. Okay, so these tests has to be carried. That's why their year is increased. That is 18 years for trees, and for other crops, it is for 15 years. Because it will take a lot of time to test them, right? That's why it is given more number of years for the production. Okay, with this one, I will complete this IPR basics. Let me go into this IPR searching. Okay, that's particularly patent searching. Okay, there are other IPRs also. For that, each and everything searching is different. But since we are dealing with the patent searching, I'm just telling you about the patent searching. So patent searching, there are different strategies we have to take care of. And these are some of the strategies we have to we are taking care of. One is the reason. And what is the reason? For example, if I'm going to search a patent such that I need to make the other companies not to infringe on my patent. If I want to do the patent, that will be my reason, right? So others should not infringe on me, right? I infringe my patent. So that is my patent reason, searching reason for that. Okay, so that is my reason for that. And the place for searching. Suppose if I want to make a business over in India, then I have to search a patent in India. In terms of India, I have to search it. So these are some of the strategies. And next, with respect to time. Suppose if I want to start a business with some patent, I need to judge how much time it is available for that particular patent. For example, if I am spending a lot of amount on that and it is only for 2 years, what is the need for that? Because after that it is getting expired, right? So I'm buying some patent from someone else. If it is only for 2 years, then it is not useful for me to buy it, right? So if it is exceeding, if it is exceeding more than 5 years, then I can invest it, right? So in that cases, that patent searching will be with respect to the time also. When this expired, when this started, when there is a opposition, when they have filed the reply to the patent examination reports, everything will be coming under this. And next one will be the keyword search. Yeah, time up. Yeah. Yeah. So next one will be the keywords. Based on the keywords, it will be done. Okay. So it will be based on the keywords, it will be done. For example, if you are mentioning if you are taking a patent, for example, if you are taking a patent of a pen, it will not return as a pen itself. Okay. So if you are drafting a patent document, in many cases, it will not return as a pen. What it will be written as writing material or drafting material, like that it will be written. So in order to do that, you have to make such a appropriate keywords, and then you have to take out all these patents. And the resources. Resources, it will be based on your where you're searching. For example, there are so different websites are there you can search from that. For example, if Indian Patent Office, then IPO website is there. If it is a world intellectual property rights, then WIPO is there. There you can, for PCT application, you can refer there. So different resources are there. So these are this will be done based on that. And I think need for patent searching, whatever I have told you as a strategy, as well as the reasons, based on that only patent searching is being done. Okay. So types of patent searching, it will be done with respect to the novelty as well as freedom to operate. Novelty means like how novel it is, right? So based on that, we will be having some searches. And freedom to operate. Suppose if a company has a patent, and how much freedom, how much boundary I have so that I can implement my patent. So that type of searching will be done in this patent freedom to operate search. And next one will be the validity and the invalidity search. As I have told already, if the patent is not valid for that much years, I'm not interested in investing it, right? So that comes under this validity search. And landscape, this is particularly important for the researchers. In the researchers, what they will do for a technical things, they will be what they will be doing is that's landscaping they will be doing. And for particular the technique, what are the other techniques are available, that will be searched in that, and it will be given as a report. That is landscaping. And these are some of the strategies we will be doing at the MAS, that is MAS Research Solutions. And whatever once you have given for a searching, then we will be doing these things. Like a subject matter, suppose if you are giving some related to the antennas, then we will be taking the searching related to the antennas, and we will be preparing some reports. And we will be taking particularly this antenna, if you are having this bifocal or bipolar antennas, then we will be going through that, and then we will be taking only particular features of that invention, and we will be searching for that. And next one will be the IPR and IPC code. IPC code means like each and every product will be given a code, so that the same code will be used everywhere. In all over the world, you can see that the same code will be used, and the searching becomes easier. And fourth one will be your searching strategy based on the reasons what you are provided. Based on that, searching strategy will be done. And fifth one will be the prior art, relevant prior art. Suppose if you want to have the prior art from, for example, in case of antennas, you want to have the RF antennas, then we will be providing the RF antenna related inventions. So we will be preparing a report based on that. After that, we will be analyzing the report, and we will be providing you the outside boundary of your invention or boundary of your idea, so that you can work on that. So these are the strategies, searching strategies we are following at MAS. So these are some of the queries. Like a query, when we are applying for the searches, we will be using these queries. Since there is lack of time, I'm not doing this. We are skipping this. And these are some of the database. This is a free databases. So you can go there and you can search for your documents. Okay, these are free and you can use it for anywhere. For example, if you are using the Indian Patent Office, Indian patents, you can search only in the Indian patent website only. Okay, you cannot find it in somewhere else. Even in the Google, you cannot search it. You can go to the IPO website and then only you can find it. So please note that it can be found in the individual websites only. Suppose if it is a US patent, then you have to go to the US PTO. You cannot search in the Google also. Some patents, it is in the Google also, you can take it. But many patents, it is individually, it is provided by the particular individual patent office, and it is free for everyone. You can use it. And these are some paid versions where you can, like whatever we are doing a patent searching, they will be giving a patent report for that, but you have to pay for that. And actually, since I planned for a quiz time, like I was trying to involve you in the searching hands-on training, but since lack of time, I'm just concluding with this. Yeah, thank you. Any doubt? Sir? Yes, sir. It is the same PPT only I have to. Actually, I want to do you this hands-on training so that you can open that, and if I'm giving one document, you can type it over there. For example, this one, if you see, all the document numbers are there, but once you are familiar, then you can see first one is the Indian pattern. Numbering will be like this. CA is for Canada pattern. So you have to go to the Canadian pattern office website, then only you can download. And similarly, next one will be the European pattern. Like that. Actually, searches are different. So I thought of giving a hands-on training mostly based on this. Because this will be helpful for your research work as well as for your invents and whatever you are providing. Yeah.
Thank you.
Thank you so much. So in case of any doubt, you can contact me at the beginning. I have given you the email ID as well as the contact number I have given. If you need any help on patent drafting, we are doing. And whatever the sir, we are charging for the drafting 60,000 sir per patent, and 60,000 it is like our overall. You can do it in the two ways. One is provisional, another one is complete. After 1 year, before 12 months, you have to submit the complete. So 1 year gap is there, so you can work it on and improve it, and then you can include it also. So overall cost, if you are seeing, it is around 60,000. Apart from the official charges. And patent searching is different. Searching, it is around 25,000 we are charging. Usually the companies, they will come for the, they will be asking for the patent searching, and we will be giving the details on the companies, like what is the related to that patent or the product. We will be giving a report. Yeah, literature survey they will be giving. Apart from that, they are giving the technical advice also, like how much boundary they are occupying, how much they can move. For example, if they are having a patent and if they want to buy it, we will tell them that this is your boundaries, you cannot go beyond this. And based on that, they will be having a valuation. Because they want to buy it, they will first find out the boundaries. Based on that, they will fix the value for that patent.
Any boundaries is what every year, every 6 months, they example.
Patent agent exam for once a year they are conducting the exams, and particularly the patent act. Only the degree is sufficient. We are like only the legal people, that advocate only they can do it. But now they have realized that only technical people can draft the things. So now they have allowed the technical people as well as the arts, science people also to be involved with it. Once they got the degree, then they can apply for the patent agent examination, which will be conducted most probably in the November. Yeah, it is sitting actually, most probably in the November. And they will be announcing the result, and everything will be completed within April. Next April, it will be completed. And one thing is like you have to go through all the books of the Patent Act, 1970. So once you have thorough with that Patent Act, then you can easily go on. Yeah.
Like last basic laws related to that.
Yes, sir. For technical people, it may be difficult first to go through this legal things. But once you understood, then it becomes very easy, and you can clear it. Yeah, you can clear it easily. And those who want to practice the patent, they have to clear compulsorily the patent agent examination. Otherwise, they cannot do it. For the sake of others, they cannot do it. They can do by themselves. But for the sake of others, they cannot do. It is often.
But it's possible to give a patent knowledge.
Sir, once it is granted, you can mention that patent. You have get the patented. Like that, you can word can be given. Otherwise, we have to mention patent file. You cannot use patented. That is offensive thing. So you have to use patent file. Yeah, since you are doing the patenting for the institute, in the website, if you are mentioning, you can mention patent file. That's sufficient. But while in the resume, if you want to include it, you can mention the patent file where it is filed. For example, if it is filed in IPO, you have to mention IPO. You have to file it if you are filing in the US. You have to mention the US PTO. That gives an advantage because you are not giving your patent only in India, but also US.
Thank you.
Thank you. Sir, ma'am, any other doubt you have? Okay, sir, let us conclude this one. And if, even if you're having any further doubts or anything, then you can contact in this mail ID as well as mobile number. Yeah. So, sir told me that there is a validity function. Okay, so we have to move there. Okay, okay, so then we will move there.
Requesting all of you to please proceed.